motion to intervene contained materials basically challenging some of the statements of Mr. Gleason and so forth. So I'm hesitant to. It's hard to go forward with this hearing when you folks haven't even seen what's been proposed, or I can just ignore the motion to intervene now. But it seems to me that the allegations and the affidavit, particularly of Ms. Munford, which is substantial documentation, may have a bearing on the merits of the claim. Are you Ms. Munford?
Right, yes, I am.
Okay.
And I would like to offer where I got the information. There was a reporter who was allowed to videotape the meeting. He published his information on his online journal, and it was a tape that's available as public record to anyone, public domain. I took the transcript, I took the audio tape of, videotape of Mr. Gleason's testimony, 14 minutes and I think it was 8 seconds, and I transcribed the entire testimony. That's where I got my information from, the recorded interview, testimony at the hearing.
Thank you.
You're welcome, sir.
Well, here's the problem right now. If I have a hearing, I can consider the, and I have to, it seems to me I have to rule the motion to intervene first. But even if they were not allowed to intervene, I believe they would be allowed to intervene. You folks haven't got the materials which they're submitting, so why don't we, let me get your thoughts. Let me start with Plaintiff's counsel.
Thank you, Your Honor. Your Honor, it's a preliminary injunction and a declaratory judgment. We think that the statute and the case law is abundantly clear. Compelling evidence is required to show that Mr. Gleason is domiciled in Kingston. Mr. Gleason has an affidavit before the court, which I've attached in today's motion as well, the paperwork as well, same affidavit, that attests to his domicile, the town of Kingston. He is a member, a sitting member of an elected board of selectmen and an elected planning board, and he's also on an appointed building committee. His life, his social, civic, and professional life, at least for the purposes of being a domicile, surrounded in the town of Kingston. So the benefit to the town of Kingston to throw Mr. Gleason off the rolls is hard to fathom. It can't outweigh the irreparable harm to Mr. Kingston. To Mr. Gleason if he's stripped of his residency in Kingston. He'll be disenfranchised. So in terms of the standards for preliminary injunction, we believe Mr. Gleason has clearly met those standards, and the town has attempted to rebut that, but I don't think it's very successful, Your Honor. The case law, and we have both copies of the Dane case and then an unpublished appeals court case, makes clear it's de novo review, and compelling evidence is required to conclude to the contrary. So while we haven't had the benefit of seeing the intervener's affidavit and their testimony, that would have to be compelling evidence to rebut Mr. Gleason's affidavit testimony. So we would ask the court to have status quo remain, have the PI continue until there is either a further hearing or a case on the merits, because there's no harm, and thus the PI standard, there's no harm to leave the status quo alone. Mr. Gleason passed the first hurdle last Friday, and we believe he continues to pass that hurdle, that he is domiciled in the town of Kingston. Notwithstanding my brother's inclusion of the decision of the Board of Registrars, Your Honor, there's one finding, and that finding doesn't lead to the result that it leads to when you look at their factual findings. Number 8, the board finds that Mr. Gleason primarily intended to establish, and then it goes on, but there's no condition precedent to lead to that conclusion. So we think the court would benefit from either testimony or some other dispositive motion to allow Mr. Gleason to defend himself in that court and the statute and the case law requires compelling evidence to show evidence.
What's your position?
Okay, so there's a couple things. I want to, for the record, I think the compelling evidence standard is a standard that faces the registrars when they're undergoing their local hearing. The standard of review here is one of deference under the substantial evidence test. while it does take compelling evidence to rebut the presumption of validity for someone's residence, if there's substantial evidence supporting that finding by the registrars, I believe the court, even in a de novo standard, is one of deference to the position. But we don't think they can meet any of the four rubrics of the preliminary injunction standard. I don't see how he could possibly, given what his affidavit is and the complaint, or even under the new motion, the harm must be immediate and irreparable. There's no question that a week ago, the harm was immediate and irreparable, a person's right to vote. That was a pretty clear case. Now, it appears that the only possible potential harm, now that the election is passed, is some speculative future vote that Mr. Gleason may take before, as a member of the planning board or board of selectmen, which, by the way, he doesn't really come up that often to sit in on those meetings anyway. He's only been up twice. Well, speculative future harm is not grounds to establish immediate and irreparable harm under the injunction standard. That's like, well, what if a couple of years from now I may take a vote on something that means something to someone? If there was any tangible evidence whatsoever in the form of an affidavit or otherwise on some immediate event that he is deprived from participating in, that might be compelling. But just saying that, hey, I'm a member of the planning board and board of selectmen is conjecture. Because there's nothing, people are members of lots of boards. That doesn't mean that what he may do on those boards will cause harm to him if he's unable to participate in those. Nor does he have a likelihood of success on the merits. Again, his affidavit really cites one set of facts supporting the notion that he is still a resident of Kingston. Got a mass driver's license, which there is no statutory timeline that I'm aware of to shed that license, at least one that's not applicable here. A car registered in Massachusetts. Those are really the facts, and that he occasionally has a residence at a relative
He
house.
filed an affidavit saying, I live here. I live here. And you're saying that this stinks, this is nuts. This guy doesn't come to the board meetings. His wife supposedly comes up and down, and she doesn't, but she hasn't really come up for any meeting. You sit down for a second if you would. You know, he's supposedly living with his brother. He has the wrong street, wrong number on his forwarding address. He listed Florida as another address on his thing. So it's not so simple from my reading. You get an affidavit from a man who says, I live here. And then the hearing was, it doesn't make sense. You know, we don't really think you do. And that's the bottom line, as far as, substantial evidence. We don't think you do.
Well, the hearing was more than that, as it says in the findings. They did rely on where he does pay his bills, where he does get mail, how often he's here, how often he's there. The fact that again, the standard is your social, domestic, and civil life.
Yeah.
His wife hasn't come back at all. He's come back twice.
She's not in this, he is.
Right, but it's indicative of where he intends, and intent is important. And intent, which is why finding number 8 is so important under the cases, under the Dane case and other cases, says your intent, where you are going to establish your primary social, domestic, and civil life.
Well, he definitely says that after the first of the year, I'm moving to Florida. I can't move to Florida now because they're doing renovation. I know there's an issue about the no building permits. Well, maybe he's really not doing renovations. But he said, he said, I'm gonna move the first year. The question is he?
Well, but they're already living there, whether he's doing renovations or not. He's in Florida. The house is habitable. Those are the findings, and those are unrebutted.
There's an affidavit from him saying, I live with my brother.
Here,
Yeah.
in Florida, he's been back twice since he moved
And you're
here.
saying it doesn't make sense?
What I'm suggesting is that under the substantial evidence test, he's got a formidable burden to overturn the decision of the registrars. And so he has a very low likelihood of success in the merits, provided that they have any reasonable evidence supporting their decision making. In terms of the balance of the harms, Mr. Witten suggests we're not harmed at all. We've got 2 vital boards for for the town of Kingston, that it will have to operate shorthanded for so long as Ron Gleason holds on.
But I thought you said they're not meeting.
No,
Are they
he's
meeting?
not meeting.
Well,
And-
that's another issue. I mean, if he's not a resident, he should be in the boards, for sure. But you're saying it's imaginary harm if he's not gonna take many votes. If the injunction's not allowed, then he's off the board, right?
That is correct.
He's gone.
He's gone, and we can go about organizing a special election or another process. It would be a special election for the Board of Selectmen and a process, joint process under statute for the Planning Board and Board of Selectmen to select a successor. So we could have a fully staffed board for whatever those two boards may do, whether it's future planning for town meetings or looking at the financial or planning issues for the town, which both of those boards do. But right now, they're shorthanded.
Your Honor, and that I think is the crux of the fight, right, Your Honor? Attorney Huggins and I represent a lot of municipalities like my brother. We're very sympathetic to the municipal position. But in this case, there's a clear attempt to remove Mr. Gleason. Whether that's right or wrong, Mr. Gleason is a sitting member of the Board of Selectmen and the Planning Board. The fact that he has a bad track record might be bad for him for policy reasons, but it's not illegal.
Here, we take Mr. Gleason's rights very seriously as well. In the same token, the Board of Registrars, it's not easy for them. This is a board that is not faced with these issues that often. It was heart-wrenching. Mr. Gleason's a longstanding citizen of the town.
And I'm not sure that they're not exactly right. I just don't know. I'm not suggesting at all that they're wrong. I just don't know yet. I am suggesting that it's a significant issue. You know, it's not like, well, there's no big votes coming out, so if he's off the board, what's the big deal? And the election's over, that's moved. So let's move on with our lives. I just don't think it's as simple as that, you know, as I see it. Well, what do we do? Let's talk logistically, and I will talk to the interveners in a second, because that's the second issue. What about if we schedule a hearing in the near future on just how to proceed? No witnesses, no anything, just with the lawyers. Anybody's welcome, of course, but.
Kind of like a mini pre-trial almost in a kind of way.
Yeah.
Certainly.
That's fine, Your Honor. We would certainly agree with that.
And you'll have a chance to look at the intervener's papers. I'll have a chance to figure out whether the intervener should be allowed to intervene and in the shape of the hearing. Whether it's on the papers, I can accept that, listen to the video, you know, I'm not sure. But I'd love to hear from counsel about that, of course.